Welcome again to everybody. We are at the top of the hour. Thank you for joining us at the Mid-Atlantic ADA Center for today's webinar, Managing Risk and Other Legal Requirements for Businesses under ADA Title III. With us today, we have Karen Coates and Carlos Lugo, both from Capital One. And at this time, I am going to hand it over to our presenters. So thanks again for joining us today.
Thanks, Carlene, so much. If you don't mind going to the next slide, that would be great. So welcome, everyone, to our webinar, Managing Risk and Legal Requirements with Title III. My name is Karen Coates, and I'm honored to be here today to discuss with you some examples of managing ADA risk. Let's start with a little introduction, and then we can jump in to our awesome agenda. As I said, my name is Karen Coates. I've spent my career in the banking industry and have more than 15 years experience in risk. I'm passionate about leading well-managed processes, and my team and I do that by using a few process tools that we'll go over today. Carlos Lugo and I work together on a daily basis to ensure our customers with disabilities are cared for. I'll let Carlos introduce himself, but start by saying Carlos has more than 10 years in the banking industry. He is an attorney that works with us to ensure we are providing reasonable accommodations to our customers. Carlos, it's a pleasure to work with you, and will let you introduce yourself.
Thank you, Karen. We are on slide 13, and the images presented on slide 13 are both a photo of myself and one of Karen. Pretty sure that's a very recent photo of myself, since I look pretty much the same. I am Carlos Lugo, like Karen mentioned. I am an attorney in regulatory legal in Capital One. I am the subject matter expert for the regulations related to limited English proficiency individuals or regulations related to other languages. And I also cover the Title III of the ADA, which includes digital accessibility. As part of my package of experience, I guess, I used to work before Capital One at another regional bank where I was responsible for ATM accessibility and the physical accessibility of their branches. And before that, I represented higher learning institutions, universities, and colleges in their administrative process when there were complaints related to accommodations requested by students. Karen, I think you're speaking on mute.
Sorry about that. Maybe I won't go back on mute. So thanks, Carlos. Appreciate you introducing yourself. So today, guys, we have a great agenda for you. We're going to talk about ADA risk accountability. Who is accountable for ADA risk, right? We're going to ask some questions about that. We'll talk about process tools. And then we have some really cool scenarios that Carlos has put together for us that we mostly could, for all of us to learn from. So we're excited to jump in. So let's do that. So let's start with ADA risk. So I'd love to ask the group, who do you think is accountable for ADA risk? If you guys can make a comment in the chat, that would be great.
We're currently on slide 14.
Everyone, the business. Carlos, are you responsible for ADA risk?
Yes, I am, and so are you, Karen. As is everyone. I love that everybody's responding. Everyone. I'm glad that we have like this type of group that everybody's accountable. Yeah,
that's right. That is right. So if you go to slide 15, this is just a picture of somebody just thinking through. Sorry, 16. Like who's accountable for risk, right? And that's what the picture is a girl like thinking about that. If you go to slide 17, we're going to talk about like we'll double click into this. So what is the definition of risk? So in Oxford Dictionary, definition of risk is the possibility of something bad happening at some time in the future, a situation that could be dangerous or have a bad result. If you take that a step further, ADA risk is the possibility of not being compliant with the ADA and creating a bad result for a consumer. In the financial area, this could be not being able to use their credit card, pay their bills, write checks, redeem rewards, visit a branch, etc. So what is Title I ADA? This isn't about that, but I think just to cover off on from a business perspective, Title I is human resources. So that's how folks take care, people get taken care of within the business that they're in. For Title III, basically the rules are pretty simple, but they're complicated, right? So Title III states businesses are required to provide reasonable accommodations and adjust policy and procedures within reason to meet the needs of our customers with disabilities. So ADA risk starts when a customer contacts the company in whatever channel of their choice, and then it is throughout the life cycle of the communications that we have our customers. Carlos, what are some of the common ADA risks that you see?
So before we proceed on that one, it is very important to understand that under the Title III of the ADA, it's not a requirement to be a customer or even a potential customer. It's more, the definition covers people or individuals. So it is in general sense, the general public that has access to potentially anything related to your business in terms of goods or services. And covering that, obviously, it covers under the umbrella prospective customers, current customer, previous customers, or anything in between. And as such, common ADA risks that we have seen are lack of ADA knowledge by company associates or associates. Given the interactions that might not go as planned, accommodations might be denied, which is one of the biggest risks there. Or lack of knowledge of what the company can provide and how they can help its customers. Sometimes human nature takes over, and our associates with the best intent try to provide or help the customer as much as they can. And that's where they enter, the little minefield of other regulations. There are certain things that we are not allowed to do, but within the spectrum of what we can do, it's what we offer within the ADA, of course.
Yep. And then one of the ones that's so there are some not so common ones, right? And this is where my team and I talk about these on a daily basis. The intent is when a customer with a disability needs something, it is our job to make sure we can provide those reasonable accommodations. Carlos, any thoughts on what's a good example of not a common example of ADA risk?
Yes. Non-common examples might be situations where communications happen through an IVR or a phone channel, where certain interactions are limited to a time frame, a very limited time frame. You get a text, you got to respond back the code that you received. You only have 15 seconds to respond. Those 15 seconds might seem like innocuous and agnostic, but in some certain instances, 15 seconds is not enough for an individual to provide that response. So it is very important that we have our ear to the ground, are aware of what our customers are saying, and are more aware of best business practices, because maybe adding 5 or 7 seconds to that IVR response time makes a difference in an individual that might need more.
Great example, Carlos. Now, Carlos is going to share with us an example of a settlement agreement between a financial institution and the Department of Justice, where relay calls were not accepted. If you could go to page 18, please.
So this is one of the biggest examples that there is for financial institution, and this was a big bank. We're doing away with names, but if anybody wants to read the case, they are available at ada.gov. This is one of the archive cases. It's more or less 10 to 11 years old. This is a settlement agreement between the Department of Justice and a financial institution regarding Title III ADA violations. This case started because customers were complaining to the Department of Justice Civil Division that this bank was not accepting relay calls. Instead, when the Department of Justice investigated, what they were doing is, besides not accepting the relay calls or disconnecting those calls, they were referring customers to a TTY, teletypewriter, or telecommunications device service within the same company. However, the interactions during those calls were less than ideal. They were getting disconnected. They would not receive callbacks. They wouldn't provide the full service of what the customer required. And that was probably because the agents managing those did not have either the permissions or the correct access. Once the Department of Justice came in and investigated, which is one of the biggest risks of a regulator coming in to review your business, they have the ability to look at everything that you're doing, not just what is related to the complaint. So they investigated their policies and procedures. They looked at their standards. They looked at all their practices, and they found out that it wasn't just relay calls. That this financial institution had issues related to ATM accessibility, website accessibility. They were not modifying discriminatory practices or policies. They did not provide alternate format to documents. They were not communicating properly with customers. And as an impact, they had to do a complete overhaul of the whole program. They had to establish an ADA program. They were required to hire at least 2 certified ADA, consultants. They had to enhance their communication policy. They had to improve the ADA compliance to ensure equal access. They had to train their associates. And one of the biggest changes that they had to implement was something that always called out to my attention, which is every associate that received calls needed to have a sticker on their computer that stated, "To assist our customers who are deaf, hard of hearing, or have speech disabilities, we accept relay calls." That is completely surprising to me because they had to go to that extent in order to correct all the issues that they found in this institution. As part of like another impact, which is, puts into frame the significance of the importance of the businesses complying with the ADA, this was published besides in the Department of Justice website. It was published on 15 major newspapers. Obviously, the intent was not to really shame the company of what they did. It was more to create a call to action to any of the customers that might have been, damaged or suffered, so that they can pull in a request for remediation or to receive some monetary compensation. But it did have that impact where, nationally it was broadcast that this big financial institution had failed to comply with the ADA.
Great point. Great example, Carlos. And in the chat, I see there's a comment, really. It says, "I noticed that many financial institutions still do not regard video relay calls as a valid way to verify a person's identity, even though they allow a voice caller to verify their identity over the phone."
That is a really good comment. And that is, I believe, something that all institutions struggle with and in terms of identifying the individual. I know that is some sort of a friction point for us too, in terms of when we have to verify our customer over the phone, the methods that we have available to us, and how these can potentially interact with customers and the protections that they have under the ADA.
Great. Any other questions before we move on to process tools? Awesome. Okay, so process tools. So with any ADA program, you can't manage what you can't manage what you can't measure what you can't manage, right? And so there's many tools that we use to see, like, what is our process, how is it running, where do we have risks, and so if you jump into page 20, here are some examples of the process tools that we use in Capital One. There are many more, but I think these are some of our favorite. And so I think I'll start with the swim lane. The swim lane is really just a visual representation of from start to finish of a customer interaction, right? And the benefit of that is, like, it helps you understand where the handoffs are and who's involved in the process. Is it a lean process, or is there a lot of steps? Is there a way to remove steps? And there's a lot of things you can do with the swim lane that's just after you document it for the first time, you sit back and look at it, right? And you ask yourself, like, what can we do to improve? And we'll get to the continuous improvement plan in a minute. From a failure mode risk assessment, you got to understand your risks, right? Like, we can accept risks, we can mitigate them, and we can monitor them. And this is a tool that you can use to document your risks and understand where you have accepted them, where you have mitigated, to choose to mitigate and take action, and document the action you're going to take, and where you're going to monitor to make sure that, if there's a tipping point, that you would mitigate or accept, move it one way or the other. And then a control plan, it helps to prevent or identify breakdowns, right? So when breakdowns happen, which they do in most processes, right? It's human nature. A control plan is built off the risk assessment, and it says, okay, if we have this breakdown, what are we going to do about it? And the importance of doing that early on is so that when you're in the middle of a breakdown, the sky is not falling. So one of the things that plan helps you do is just lay out when there's a control break, this is what we're going to do about it. And then last but certainly not least, a continuous improvement plan. This is honestly, every process has, can continue to improve. And so it's really just a place where, you can put your items that you want to work on. It could be where, you have things that you want to mitigate and you put them on the list and then you prioritize that list. And so you can continuously see the improvement in your process. That was a lot of information. Before we jump into like, what are some examples and where can you get some templates for these? Carlos, I wanted to see if you had anything to add about these tools.
I do. Given that these are all, very important process tools to manage risk, from a legal perspective, for me, the one that is most significant is the swim lane and the control plan. The swim lane is where you plan before and ahead any type of situation that might occur, and you have a established plan developed for your associates to follow, or a specific set of instructions that will kick in place whenever a situation happens. Either you're fulfilling an accommodation request, you are servicing a customer that has a specific need, or you have the capacity to start the conversation and go into the one-on-one interaction to find out how better you can help that customer. In the control plan, that is significantly important because it is better to know the issue and have a remediation plan to correct it than being ignorant or being unaware. Once you get a complaint, either via a formal process like a regulator or a court case or attorney letter, it usually the situation is at that point where you're scrambling to find a solution, and you're struggling to find a way to effectively defend yourself. But if you were aware of the problem beforehand and you already had an established plan, that is a perfectly reasonable response in a legal environment. When it comes to the ADA, we are aware of the problem, we are finding a way to solve it, and it starts the whole conversation with whoever filed the complaint with you. In most instances, the individuals who actually file or complain about a situation have the best interest in mind. They want to correct the action. They want to have access to your products. Is not necessarily a situation where just seeking monetary compensation or attention. It is usually a well-intended customer that actually wants to acquire a product of yours or want to get your services.
Yep. Great feedback, Carlos. If we can go to page 21, please. So this is just some examples of the swim lane, FMEA, control plan, and continuous improvement plan. You can really go on the internet and type in any of these tools and look for templates that are free. And it's just, you use what you use what makes sense most to your company. I think the thing I would walk away with that's most important is these are living documents, right? It's not once and done. And so making sure that when you're documenting something, I'll say it lives in draft form for a long time, right? Annually, you look at it to make sure, but you should be looking at it all the time as something happens, as a trigger event happens. So next slide, please, 22. So what are some best practices for consistently executing process? So I'll start with engaging stakeholders. We already agreed that everyone is accountable for managing ADA risk. It is so important that stakeholders across the organization are educated and included in training on how to manage ADA risk, whether that's sharing reminders via email, whether that's videos, whether you're updating frontline associates in their knowledge management systems. It's just really important to up and down the chain of communication that we keep ADA the forefront of the stakeholders' minds, right? In the example that Carlos showed on the bank in the beginning, there seemed to have been a lack of education, and so then they had to overcompensate for it, right? So it's just really important to make sure that all of the people within the company are educated and understand what their role is. Any thoughts on engaging stakeholders, Carlos, before I move on to the other two?
Yes. This is significantly important because of that. that initial training, that initial understanding of their obligations, the understanding that everybody's accountable for ADA, it's significantly, important every day that it passes. In some instances, a situation where they have to proactively, execute your ADA policies might be once a month, once every 2 months. It might not be, something that happens every day. So having a written down process for your associates to follow is very important, since some of these scenarios are not common. And some of them, might occur every once in a while. So it is a way for them to, if they don't have it active in their mind, at least they know where to get the information that they need in order to appropriately engage with their customers. From the other end, from the internal perspective, engaging with your stakeholders is really important. Compliance, legal, risk. If you don't have, an attorney in your company, try to engage with an outside counsel to at least help you with this type of situation. In instances where, your program might not be as sophisticated, it doesn't have a compliance advisor or a legal advisor, there are still resources out there from the different organizations like the Mid-Atlantic Center, the U.S. Access Board, that offer, guidance whenever it's requested, and they can answer particular questions.
Thanks, Carlos. One of the other best practices that we wanted to share was around updating your documents periodically. I mentioned earlier that they are living documents. As your process evolves, some won't change on a monthly basis, but I'll use the FMEA for an example. So if you have a breakdown and you decide that you're going to mitigate a risk, you need to go up into your FMEA and change it from accept or monitor to mitigate. And then you need to go to your control plan. And as you're talking through it with your team to say, okay, what are we going to do to fix this problem? Then you want to go into your control plan and update what you're going to do to fix the problem, and then hold yourself accountable to it. So the documentation periodically is, so many times we get busy at any company and we document something and we check the box and we put it back on the shelf. And then annually we look at it. Best practice we want to share today with you is don't do that, right? Like, you make sure you are actively using these documents. When I actually was working in the office and I started a new process, I would actually have them out on my desk and make pencil updates on them. And then once a month go in and make the updates to the documents online. So any other thoughts on the updating documents periodically, Carlos?
Yes. I believe that these should be treated as similar to journals, right? Where you record and keep track of what's going on within your ADA compliance. A call out that I'm gonna make for everyone is, as best practice, please try not to record anything related to customers' disabilities or personal information related to customers. If it has to be framed in some way, the best way is to capture the accommodation provided, so that it can be provided in the future. It can be a repeatable event, or you have it as an example of something that your business has effectively concluded in the past. However, you should refrain from keeping any type of information that could potentially be used for discriminatory purposes, even if it's unintentional, like recording the type of disability, recording the information of the individual, the customer associated with that type of disability, or anything related to that. These documents are what gonna help you keep your process in a well-managed way and want to maintain you in a consistent manner. It's gonna help you provide accommodations in a consistent manner where and have effectively be able to reach out whenever similar situations happen in place. This will also allow you to identify trends within your business or your company. If you see that you're getting too many requests for a particular thing, it would allow you to, I guess, reverse engineer the type of product that you're offering or the service to see if you can prevent those requests for accommodations in the future and actually build in a feature in your product to accommodate for that.
Great points, Carlos. And then last but certainly not least, best practice we want to share is attending conferences. When I went to my first ADA conference, I really thought that I understood ADA. I had studied it. I was leading this team. I had never been so humbled, honestly, in my whole career. It really had never occurred to me that if a company did not build the bathroom big enough, then a person in a wheelchair could not go to the bathroom. I learned so many other lessons and continue to learn. And that is why it's so important to continue to go to the trainings. Different disabilities, different things come up. And the common thread through those conferences is learning together, and then taking that learning back to your whatever company you work for and making changes where you seem necessary. So I would just say, where you can attend the conferences, attend these webinars, invest in the Mid-Atlantic ADA Center, and because it's important and it's going to help your customers. Thoughts on conferences, Carlos, before we go to the next slide?
I would also recommend participating in peer groups, if there are any within your industry, and besides attending conferences, and being aware of technology trends. The conferences are really good for this, as you see vendors offering different products. This is one of the best places to be aware of new technologies that might help you in your ADA compliance program, or even in the conferences itself, like the commentaries and questions that people bring. Like Donna just asked a question about video relay calls, and that is a really good one, where it potentially could be a future in terms of adapting a type of different service that you can identify your customers, and it also helps in a manner of speaking our customers under the ADA.
Yep, great advice, Carlos. Any questions on best practices or the process tools before we move on to scenarios? If so, if you could put them in the chat, that would be great. I'll give you a second. Do you have advice regarding getting employers to support attending conferences? I am the only ADA coordinator at my company, and they don't understand why I need to attend. Carlos, any advice, or you want me to take this one?
I think that we should both comment on Sarah's question.
Okay, go for it.
Sarah, from my perspective, it is a multiple pronged approach. For the business, it is very important for them to understand the risk associated with non-compliance with the ADA. So depending on the size of your company or the size of your business, it might be a good idea to identify similar situations or cases. The scenarios that we're bringing up today that I selected for this try to be as broad-reaching. They're not all related to financial institutions. So if you have something that could be brought to their attention that is similar in the industry that you work on, and you can show them the risk of non-compliance or the effect that it has had on other companies, it gives them a little bit of an idea. Another issue that you might bring up here is that depending on the size of the company, it might be a requirement to have more than one ADA coordinator. For example, the case that I spoke earlier about the financial institution, because of the size of the financial institution, they had to create an ADA program and they had to hire 2 ADA coordinators, not just one.
Yeah, I mean, I think to Carlos's point, I think whatever business that you're in as the ADA coordinator, any of these scenarios that we talked through today, and we're going to talk through 4 more in just a second, that align to your business, that same mistake could be made in your company, is a good enough reason to be able to go. I think the other thing I would say, as far as the ADA, Mid-Atlantic ADA, and then the National ADA conferences, they do a really good job of laying out their classes and what they're gonna be doing during the conference. So I would just highlight those too, right? So when I ask for permission to go to a conference, I usually will forward the email of the agenda, and I'll say, hey, I'm going to attend this conference. Here's what I think I'm going to get from it. Please let me know if you have any concerns. So I ask permission, but I ask it in a way that shows them that why I'm passionate about doing, or what this is going to do for our company. So that might just be one other way that you could present it.
The other way that you can work with this is build a business case, right? Not everything has to do with the scare of a regulator coming in and investigating your company or the threat of a lawsuit. You can also build a business case as to why it is in their best interest to be ADA compliant. This is a reputational issue, right? If we are compliant with the ADA, we maintain a good reputation as a company. This is also, open for the availability of new customers. Given that that is a company that would be considered, compliant with the ADA, it would be easier for customers with disabilities to access those goods and services or your products. Another, not so easily described example is whenever you plan for digital accessibility, if you have a website, yeah, and you have a website that is completely digitally accessible, usually what has been noted is that the net promoter scores for that company go up significantly. Another is that they're eligible for a lot of, prizes and awards that are giving out throughout the industry of like best, accessible website or the best industry website for X type of business, because people take note. They understand that there are certain limitations within the scope of what can be done, but whenever your business or your company actually does provide a little bit more than what is legally required, it gets noted.
Yep. Great feedback, Carlos. And then Frank made a point too in the chat. Also important to point out that ADA is ever evolving through judicial decisions and legislation. So, awesome. Any other comments, questions before we jump into scenarios? Okay, well, can you go to page 23, please, Carlene? All right, so we're going to walk you through 4 scenarios in detail and talk to examples for each. In each scenario, my advice is to ask yourself, how do we do as a company, whether you work in a bank, whether you work at a company, how do we do in this space and what can we do to improve? Our first scenario is opening a bank branch. So page 24 is the pictures. It's not really pictures, but on here, we're talking about potential risks and some mitigation. But from opening a bank branch perspective or opening a brick and mortar location is the same type of risks. So the 2 risks I want to talk through today are buildings not ADA compliant, which kind of was my example from the conferences, right? There's many more things that can happen. Whether if somebody gets, if there is not a curb for a wheelchair to go up, they can't actually get to the brick and mortar. If there's no ramp to get into the brick and mortar location, then they can't get in the door. If the door doesn't open, that's like it's too heavy, they can't push the door open. So there's so many things in this space that it's really important to bring in somebody that has the skill set to be able to help a company be compliant with the ADA rules when it comes to opening buildings. And then the other one, the risk that I think that I wanted to talk through is not being trained. And we talked about that a little bit with the first scenario that Carlos went over. And we talked about it a little bit in process documents. But it is just so critical to whatever, again, this is about bank branches, but any company that has associates has to continually remember, like, how can we make sure that this is in the forefront of their mind, right? There's just so much that we expect of frontline folks. And in the brick and mortar locations, it's face-to-face, right? So it's not more important necessarily than a call center, but it's more personal from a person exchange. So I think from that perspective, I think just making sure that you're, again, using your swim lane documents, looking at your FMEAs, and just making sure that where there are risks that you're choosing to mitigate, monitor, or accept them, and going forward from there. So Carlos is going to walk us through a scenario with the DOJ and Holiday Inn Express that has to do with some risks associated with opening a brick and mortar location. If you can go to page 25, please.
Before jumping into the scenario, I also want to call to the attention that, appropriate selection of furniture and fixtures is also extremely important in the design of a physical space. This is a scenario where it's a settlement agreement between the Department of Justice and the Holiday Inn Express Hotels and Suites. This is a situation where a couple and their in-laws called in the Holiday Inn to request reservations. They wanted to spend Thanksgiving close to their family and close together. They requested 2 rooms with accessible showers for wheelchairs. When they called, they made the reservations. Everything seemed all right. Once they arrived to the location, everything was not really all right. The hotel staff indicated that the rooms were not available. In the settlement agreement, it's unclear if the hotel even had available accessible rooms, or if these were given to somebody else, or if the staff misrepresented the availability. Regardless of the situation, the couple had to find other accommodations. They were not close to their family. The in-laws decided to stay in the Holiday Inn while the others went to another hotel that actually had accessible rooms. It separated the family throughout Thanksgiving. They suffered some emotional distress. And they filed a complaint on the Department of Justice. Once the Department of Justice investigated, they made a determination that there was actually violations of the ADA. It is, again, unspecified if the hotel actually had the accessible rooms available or not, and it was an issue of the associates, or if it's actually a lack of availability in terms of the rooms. As part of the impact to the business, they had to hire or contract a independent licensed architect that was approved by the Department of Justice to investigate, the physical location or the hotel. Like, they had to provide a review of it. As a result, the hotel had to add 2 king accessible suites to their roster. They had to return the services of the independent licensed architect for further examinations. The staff had to undergo ADA training. The hotel had to submit regular reports to the Department of Justice, which included the independent licensed architect's reports. And they also had to pay $10,000 to each of the affected parties.
Great example, Carlos. Any questions about this example?
I brought this example as something particularly important to call out how important it is to get it right in the design phase before you actually launch a business or open a new location, given the significant monetary impact or the disruption that could have to your business. It besides, the affected experience of a customer, depending on the interactions of your associate, if they're not adequately trained, it could suffer some reputational damage. And at the same time, it suffers significant damage in terms of the regular practice of the hotel, in the sense that they had to build 2 additional rooms or refurbish or retrofit. They had to have an architect that required, periodical reviews. Carla, that is a really good observation in terms of seeking monetary settlement for a complainant. That is actually accurate. It is not the purpose of the ADA to seek a monetary settlement for a complaint. For this particular case, given the disruption that they suffered, they also claimed emotional distress and damages in terms of missing out the time with their family and with their in-laws and the plan from the trip. So it was more around compensation of the loss of time and the disruption of their time. So it wasn't entirely based on the ADA. That was also a tort action that was, wrapped in itself. But the actual ADA case was settled between the Department of Justice and the Holiday Inn Express company.
Yeah, and Carlos, you called this out earlier. Well, I'll let you finish answering Carla's question. She also asked who bought the action forward.
The couple that actually were misrepresented in terms of the accessibility, because in part of their complaint, they also claimed damages. They complained emotional damages and distress, and they also claimed, the loss of spending time with their family, the loss of the experience, having to get another type of reservation, having to drive farther away. It was wrapped into one. They claimed they brought it into the court case, but because this was settled out of court and within the settlement agreement, the Department of Justice thought that it was convenient if it was just all decided in one way, in one matter, so it would settle or close the case. Yeah.
And this is another example of, like, if it were me and I was that person and I was as frustrated as this case makes it sound, how many other people did they tell? Anybody that would listen, I would tell, like, can you believe this company said they had this? They didn't. We couldn't spend Thanksgiving together. We had to go to this other place. So I think from a reputational risk perspective, this is another, beyond the settlement agreement. It's just something to make sure that companies look out for.
And I want to mention, Carlos call out is really important and very accurate. The other scenarios also have a monetary component to them, but they didn't seek to pay damages or monetary recompense. The future scenarios or the other scenarios that we're going to discuss today that have the monetary component are more for basically make the individuals whole or repay costs associated with the issues that they suffered.
Makes sense. Carla, thanks for the question. Carlos, thanks for the answers. Sarah, I see your question about conferences we recommend, and I promise you we'll get to that at the end since we've moved on. So hold me to it. All right, so the next scenario that we're going to talk through are opening on credit card accounts. So if you can go to page 27, that would be great. So companies do their best to make opening products easy, right? You can go online. If you're on your phone, you can like, hey, you qualified for, you pre-approved, fill out these 4 pieces of information and we'll let you know if you're qualified. It is critical, as we are in the world of digital everything, that we ensure that there are exception processes for people who cannot apply digitally. I think we see it all the time where, somebody wants to open an account and they can't follow the process and it's frustrating to them. And so no matter what, I think as ADA professionals, it's really on us to make sure that our companies that we work for, anytime they come and say, hey, we're just going to do this digital thing, that we push on what's your exception process if somebody can't do that. And then Carlos, he has another good example for you, is he's going to walk us through a scenario where the DOJ and Uber reached a settlement agreement. And this is a really, really good example of intent not matching execution. Carlos, take it away.
This is one of my favorite cases to bring as an example, because like Karen mentioned, this is an example of intent not matching execution where good intentions only can get you so far. This is a settlement agreement between the Department of Justice and Uber Technologies. And the issue at hand is that Uber charges a wait time fee on rides when the rider doesn't get to the vehicle within 2 minutes. You have 2 minutes to get to the vehicle once it arrives to your location, and anything past that, it assesses a wait time fee. Now, in order to solve the potential issue of individuals needing more time to get to the vehicle and actually getting on board of the vehicle, Uber created a waiver program. The waiver program's intent was to capture if individuals had any special needs or disabilities that would require them to take longer, or that require them, some longer wait time, so that the fee wouldn't be assessed to them. However, the program was fraught with issues, and it drove complaints to the Department of Justice. And when the Department of Justice investigated the case, they discovered that there was violations of the ADA and there were discriminatory practices within the Uber Technologies company. Now, the issues in the program where people could subscribe to it, but Uber will require evidentiary documentation that you actually, had the need of an accommodation. Whenever they receive certain documents, they usually denied the claim and would continue to assess fees to those riders. They were not readily available in terms of publicizing the waiver program, and it wasn't really effective at all, to the point where over 65,000 customers complained about the waiver program to the Department of Justice. Once they were investigated and they actively identified the issues on the program, Uber had to modify their policies. This is another good example of the ADA imposing the need to modify or alter your policies and procedures internally to make it more accessible. In this case, there was unintentional discrimination, right? So they had to be lax in terms of the requirements of who could participate within the program, who would qualify within the program. They also had to train their associates in order to be able to provide information about the waiver program and who would be eligible for the waiver program. They had to make the program agnostic or something that wasn't visible to the drivers. Because in some instances, if the driver noticed that the individual would not be assessed the wait times, they would cancel the ride and they would, leave them stranded basically, or make them make an additional request for another driver. as part of the impact to the company. This is one of those cases where the monetary impact is not meant to be, the payout of damages. It is more restitution. Uber had to create several different funds in order for individuals that were affected to be able to claim a restitution on the fees that they were assessed. Uber had to provide credits to the individuals that they had on record that were supposed to be, waived the fees, and they were charged with these fees. And at the same time, they had to pay civil penalties to the Department of Justice.
Yep, it's a great example. Questions on this one? This screams to me like a waiver program is a good idea, right? Like, at the end of the day, though, you have to be flexible and be able to, meet your customers where they are. Thoughts or questions about this? All right, well, let's go ahead to page 29, please. So launching company websites. This is a hot topic. They have many conferences. Sarah, you asked about conferences. If your company launches a lot of material on a website, there are many conferences around digital accessibility that are really good ones to go to. But ensuring company websites are accessible is critical, right? So that our customers with disabilities can have the same access to products and information as all customers. Using training and tools to test the websites is recommended. It is so important to listen to our customers and take action, right? Taking it back to our process tools. If you're monitoring, but hear enough concerns from customers, then you should mitigate. You could possibly prevent DOJ issues. Carlos is going to walk us through a scenario with Hy-Vee, which was a vaccine registration portal used during COVID. This is a really interesting scenario, so listen up.
I found that it is easier to think about digital accessibility or website accessibility if you think of it in similar terms as physical accessibility. The difference being, obviously, one is a physical location, the other one is a digital location or digital property, but the issues are pretty much the same. If the customer cannot access your location or your website, they can't acquire your goods or services. If there are issues in terms of the pathway in order to enter or even reach where those products are, they can't access your goods or services or even become your customer. And those are all clear violations of the ADA. So it's very similar to having a clear path of access, having removing all those barriers for the equal enjoyment of those goods, or even have accessible services in terms of being able to acquire them. This particular case is the settlement agreement between the Department of Justice and the Hy-Vee Corporation, the Hy-Vee Incorporated. This is a vaccine registration portal for COVID-19 vaccines. The issues around this portal were incredible. Like individuals with a screen reader or individuals that would need to only navigate through a portal or a website via keyword, they wouldn't be able to access or even register. So once the site was investigated and reviewed, it was determined that it was completely inaccessible for individuals using a screen reader. It was unmanageable or not being able to manage it with individuals that only use the keyboard. So the impact to the company here was that within 10 days of the effective date of the agreement, which is the settlement agreement, they had to resolve any critical issues related to instances of non-conformance. The standard that they used here was the website accessibility. It was WCAG, basically. Let me see if I can find the expression on it. The Web Content Accessibility Guidelines 2.1, level 2, level A, or WCAG standard, which is an international standard for digital accessibility. Recently, the Department of Justice provide guidance that this is a standard to be used when it comes to digital accessibility. So this is the one that they imposed to this company. Besides, obviously having to solve the major barriers within 10 days, they also had 90 days to solve for effective conformance to their website. So this is very similar to a lot of compliance programs where they have a remediation table, depending on the criticality of the issue that is discovered. And um, the web content accessibility guidelines provide, a clear understanding of what is a critical error, what is medium, or what is low.
Thanks, Carlos. Any questions about Hy-Vee in this particular scenario before we jump into our next one? All right, I'll take.
So before
Yeah, go ahead,
we move on this one, given though I haven't seen any questions, I can provide a little bit of more. There hasn't been any major changes to WCAG in the past 3 years, but there is actually a process to draft the next version of them. We have been waiting for them for maybe 6 months. So there isn't an expected publication date, but it is the coming soon type of timetable. So hopefully we'll see within the next year, the next iteration. Another thing to understand is that it has 3 levels of compliance: level A, level AA, and level AAA. AAA is a aspirational standard right now. There are requirements under it that are very difficult to attain in terms of technology wise. So basically, the recommended standard level is A and AA.
Yeah, and then
that would be a good idea to have another webinar on the changes. Richard, in order to determine if your website is compliant, there are numerous free tools that you can use. However, you have to be aware that those tools are not perfect. They might provide you false positives, or they might even provide you with false negatives. So they can tell you the website is better than it really is, or they can tell you the website is worse than it actually is. So what we have determined internally is that as a best practice, we run it through 1 or 2 different tools in order to assess, if there are significant differences between the tools. And we also have a manual review. Try to have somebody navigate through your website with a keyboard only, using a mouse. Try to activate, accessibility features on your computer, text to speech, or use a screen reader to actually see if everything is identified correctly. There are certain things that you can actually check by yourself, like the color contrast. Since WCAG is very effective at providing you the ratios in terms of how it should be. When you have, a color background versus the size of the font, if it has to be, size 18 or size 14 bold, or, all that stuff you can review manually. Usually the tools that are available online would mostly check if your images are appropriately labeled, if there is correct transition between one website, one page and the other, if they are, identified properly or indexed properly. Because these are things that, users that actually can see the content of the website doesn't even notice, right? But if somebody's just using a screen reader and you navigate from one tab to the other and they are not indexed properly, what is going to tell back to that user is that they're moving from page 1 to page 15 and from page 15 to page 7. So it might not make sense to them. So indexing correctly, labeling correctly, that is all something that can be easily done. And it makes wonders in terms of putting your website up to compliance.
Yeah, great point, Carlos. Also, I would say, Richard, this is where you should true back. In companies that don't have tools or don't have funding to get anything more than what you have and aren't 100% comfortable, make sure you're using your process tools to say, hey, this is a risk. We know it's a risk, and we're either, here's the way we're solving for it. We're using this free tool, or we're doing this manual step. But there are still some risks with that. So that if you ever do get complaints, then that's a trigger for you to say, hey, now we've gotten enough feedback that we may need to invest in this. And Carla, I think it's a great idea to have another webinar when the changes come in. So Carlene, we can talk about that at another time. All right. Any other questions on Hy-Vee and any of the scenarios we've talked about so far? All right, well, can you go to page 31, please, Carlene? So hiring new frontline agents, right? So whether this is a call center associate or it's a brick and mortar associate that's face to face with their customers, it really is important to make sure that they get the proper training. We've talked about that throughout this document. And it seems like, oh, well, that's kind of a no kidding. Of course you need to do that. But you won't believe how many times it's missed, right? So some potential risks here, like scared to handle a relay call. Like that's a real thing, right? There are people that have gotten bitten by animals or just, are afraid of them, and they work in a brick and mortar location and somebody's going to bring in a service dog. What do they do with that? And it's just really important to have a plan, right? So whether, I can't say what the right plan is for a company, but like there are many options, right? If they're not the only person working there and it's something, like they need to work that out with their employer and most importantly, document it and make sure that they have a plan. I think, hiring customer service agents happens at most companies. Ensuring that customer facing associates have the proper training, as we've talked about many times, is critical. But one potential risk in service animals is like nowadays, people have emotional support animals. They have dogs, they have ponies, they have donkeys, they have snakes, they have cats, they have, you name it. It's whatever makes them comfortable. That even escalated during COVID, right? COVID was hard for everybody. People were lonely and they picked up emotional support animals to help them, help them. So it's really important that associates know, especially in those brick and mortar locations, what they're allowed to do, what they're not allowed to do, what questions can they ask. Carlos, I'll ask you as me in this space, like, I know you have a lot of passion around this topic. What would you like to share with the group that's on the phone regarding service animals and how somebody that's approached in a company should handle them?
So this is one of those moments where you have to sit down with your leadership or whoever can make the decision and have a serious discussion, right? Like the company has to establish a policy of what they're going to do between an emotional support animal and an actual service animal. Obviously, service animals are covered under the ADA. We have to allow access for them. We can only ask very few questions, and one of them is what task the animal is trained to do, so that we understand, if the appropriate behavior that the animal is exhibiting is correct or not. And the other one is more around the assessment of making the determination if the animal is under control, right, of the individual that is managing him. But for emotional support animals, since they're not really covered under the ADA, it is important that the company, make a decision as to what they want to do. Depending on the industry, obviously, this might not be a big issue or a big problem. But if you are in the food service industry, having also the animals inside of a restaurant can create a health issue, and it might not be even allowed depending on where you're licensed to operate. So it is very important that that also comes into mind, since even though it's not covered under the ADA, it is very close in terms of emotionally close to the situation where we don't want to upset customers, right? Like we want to do or try to do as best as they can. We're talking about service animals under the Title III of the ADA, not under Title I. And that's a question that we got from Carlene. So this is more of a situation where, the company needs to establish their own policy for emotional support animals and what they want to do. If it's something that is, easily provided and the company might not have a lot of issues around it, you can establish some controls as to the type of animals that will be welcome, as opposed to animals that could potentially be, threatening to other, customers or even your own associates. But in terms of service animals, the limitations are more around understanding how to address them and how to handle them. There might be an instance like Carlene's question of discussing service animals between Title I and Title III is very important too, because there might be a situation where you have an associate that is allergic to dogs or deadly afraid to dogs, and you have regular customers that actually come in with their service animals. How do you create a safe environment for your own employees and at the same time a safe environment for your customers? So this is where, it's really important to know how to distinguish between a Title I issue and a Title III issue. and how to address appropriately any potential concerns that your own employees might have, and how you can help them throughout, the journey.
Makes sense. Great advice, Carlos. I think before we jump into the scenario, Carla points out something that we'll talk about after we close out the next scenario. Carlos, so hold tight. It's a good reminder. So Carlos is now going to walk us through a scenario with a company that actually is a consent decree, which is a little different than a settlement. So can you explain that to us, Carlos?
Yes, of course. So all the examples that I've brought so far have been settlement agreements, which are, in between the private parties, and they are usually done outside of court. It is usually in the best interest of both parties to settle the case. They don't want to air, the dirty laundry. They don't want a court decision that determines somebody's culpable or not. A consent decree is a little bit different because it is a negotiated agreement and it is entered in court. So the judge makes a decision over the agreement, approves it or does not approve it, and enter into a court, and is enforceable by court. So any parties in violation of the consent decree can be taken back to court and, pretty much have a judgment served against them. In this particular case, it is shocking to see that a consent decree between the Department of Justice and a medical services company, after 30 years of the implementation of the ADA, things similar to this happened. The issues or the complaint based in this case was that individuals with disabilities were being denied medical services. Patients that had mobility issues or were in a wheelchair were required to pay for their own service and their own assistance when they were being transferred from the wheelchair to the surgery table or to the examination table or to the x-ray tables. At the same time, the employees of the facility, of the medical services facility, were being discriminatory. In some instances, they were driving away patients that had disabilities and telling them to get their medical services across the street or in other locations instead of where they were going. Obviously, these all are, blatant violations of the ADA under current standards. So the biggest impact in this company was that they were found to be discriminatory. So they had to create non-discriminatory policies. They had to create trainings for their associates. They had to hire services to be able to assist their patients with disabilities in terms of the mobility. They had to refund and create some fund for monetary restitution for those that were actually charged, or those that were actually turned away, or those that had to pay for their own services in terms of the transport. And they also had to pay civil penalties to the Department of Justice.
Thank you, Carlos, for sharing. That is really an interesting scenario that, it's not, another good example of to learn what not to do, right?
I mean, this one is a little bit shocking, right? Because it is clearly an issue of discrimination in terms of the practices that they had. But sometimes, shock is what drives, folks into action, or is what drives real change within a certain environment. And this one is to clearly identify the difference between how you hire and train your associates and how you create actual policies that are non-discriminatory, right? Like if your policies themselves are unintentionally discriminatory and you're not providing appropriate guidance to your associates, or are explaining certain roles and certain responsibilities that go beyond, their regular roles and responsibilities. This might have been an issue where, the orderlies on this facility did not want to provide any sort of help because they might have thought that it wasn't part of their responsibilities. This is another situation where, the policies might have been too strict and the associates might have been obligated to not act. They might have wanted to help, but they couldn't because of company policy. So it is very interesting, right? Like, and sometimes, certain things that are for a lot of us common sense are not really that common.
Yeah, that's a good point. I think the other thing this one screams to me is, hey, if I was an orderly here and I realized like this is going to get us in trouble, speak up. I'm not saying like get yourself in trouble. I'm saying in a respectful way, make a point like, hey, do you realize that customers with disability, like we're not following the rules, and making sure, like, if it were me, I'd want somebody to tell me like, hey, Karen, do you know we're not doing this right? I'd want to know. And so I think it's important, back to the whole, like, who is accountable for ADA? We all are. And I think this is another place where, and I'm not saying they didn't do that. For all I know, they did, and they weren't listened to. So that's not like, I have no idea, but I think, I empower all of us to point it out in the companies that we work for, to say, hey, I see this risk. Is it something that you're worried about? Should we be worried about it? Let's talk to compliance. Let's talk to legal. Should it be on our FMEA? Because it's just important to ensure that, we're doing the right thing by our customers. So one of those things of like, see something, say something, right? So interesting. Well, that is all the slides we have prepared. I think we have a couple of comments I wanted to address, and then I wanted to ask for any other questions or comments. Carla made a great point when we were talking about web accessibility, to remind this group that also the links that so if you have a website and then you have a link to other websites, that also can make your website inaccessible if they're not compliant. So it's complicated, right? So just making sure that not only, if you have your website, but anything that links to your website has to also be accessible and follow the WCAG. So
At the same time, the other way around too. Like if you have a link to another website within your website, you make sure that it's appropriately labeled and it establishes, or provides the correct information that it is a link to XYZ and is moving you outside of like the experience of your company. It's taking you to a third party. So it works both ways. If there's a link to your website somewhere else that links it in, or if you have a link to another website within your site, your environment, that takes people out.
Yep. And then the last question that we received was, what conferences do we recommend? Honestly, the Mid-Atlantic Center, both the Mid-Atlantic Center and the National Center, the one that's in May, for the ADA Center, are all good conferences. I think for me, it comes back to making sure that you're, again, check the agenda, make sure it's something that would benefit you and your learning. But really, and then from a WCAG perspective, there are many digital accessibility conferences. I'd say like Mid-Atlantic, Carlene and team have a ton of knowledge on that. So they might kill me for it, but reach out to them if you have any questions. Oh, it's National ADA Symposium. Thank you. I'm like, I know I'm not saying it right. That's the first one I went to. And I think if you've never been to one, either that or the Mid-Atlantic conference are the two ones I would suggest, highly recommend.
Tiffany made a comment in terms of so many times accessibility is not viewed as a goal, it is viewed as an afterthought, and that is very true. That's why we go back into the adage that everybody is responsible for the ADA. So if there is a way that you can bring that to your company and make them aware that it's not just one individual's responsibility, it's the whole enterprise responsibility. Also building a business case, right? Like as an example that I was bringing earlier, having your website compliant usually has a good result in terms of reputation, of the net promoter scores for that website going up. Gaining potentially more traffic through the website and getting more access. This is a very active environment and community. So if your website is accessible, people are going to notice. They're going to know. You're going to get more customers. It's sometimes very difficult to put into numbers, but they are good, and I have seen them in the past. They are good conferences on how to build a business case for ADA compliance. And I would recommend any of those. Rachel asked a question about brick and mortar businesses and what are the most common complaints. Rachel, most common complaints are related to wear and tear items, things that break every day, things that are movable, door push and pull requirements go out of alignment. Those are very common.
The counter's too big.
The counters are too high. The carpets. So the best assessment that you can do is try to establish, if you can't solve for all your problems, try to establish a risk mitigation strategy where you don't solve for the whole thing, but you're mitigated to the point that you control the biggest issues. Try to establish a plan from, the pathway from the outside to the inside and getting to the places where you provide your services. Try to prioritize, from gaining access into the building or the location into gaining access into your products and services. And you can start from there. If you still have time or money to keep on repairing or fixing anything else, start expanding outwards. Look at the services that people usually or customers, most widely use after actually going into the building, like bathrooms or the locations where they can, spend time or be with. Those are the spaces that actually are most important, most impactful, because, those are the ones that are widely used. That's the one that people are going to notice if there's an issue or a difference. Yeah. That's why I made the comment of, the doors, the carpets, the wear and tear on the carpets, if it's a tripping hazard or, for the cane detection, if it's something that is be affected. If you have a lot of furnitures, like in a restaurant, tables that are accessible, have the appropriate number of those. If you have different locations within your business, like conference rooms and little offices, that you have the appropriate room of accessible conferences available too. So all that is important because those are the ones that are going to be most notable.
Yep. Somebody makes a comment about the landlords. I was just going to say some buildings are leased and you can't do anything about, like, certain things you can do something about, but you can't do something about big things. But I've heard where companies, even smaller brick and mortar companies, like you can put a sign on your window that says, "Hey, if you need service and you can't get into the location, call us and we'll come to the car." Right. So there are things you can do if you think outside the box. Again, back to the whole, for Title III, it's provide reasonable accommodation or change your policy and procedure when necessary. So there are things you can do. I think it's just a matter of making sure that that's what the policy is for the company that you work at. And then one other thought I had to the person that made the comment about accessibility, about being an afterthought. I think you're right, but good input is good output, and that's where we need to all start. So making sure that the folks that are building our website are educated, that they do work with the digital accessibility teams, or if they don't have a digital accessibility team, but it's not a huge company, that they do work with the tools that exist to put them through before they publish the website. Right. And that's something that all of us can continue to work with our teams on and making sure that they do that.
I love Frank's comment on the 36-inch pass of travel. That is one of my personal pet peeves whenever I go into a convenience store, supermarket, or any type of store where obviously the aisles are built to be accessible, but proper lack of training for internal policies or associates in the store that leave like the stairs in order to restock in the middle, or you see carts that are not picked up in the middle of the aisle that block that type of travel path. Those are temporary violations of the ADA. So it has to be called out that, just moving an item out of the way might be enough to create an environment where it's, ADA compliant. Yeah,
it's a great point. The only other point I would say is in many of the settlement agreements I've read, what's missing is listening to your customers, right? If, I know every company has like an ADA program where they'll listen to calls or have a QA program where they listen to calls and things. But I know in the first example that Carlos gave, they were told, if you would have just listened to your calls, you would have heard this. Right. So make sure, again, if you have no other tools, if you're QAing somebody, if it's a brick and mortar, observe. If it's phone calls, listen to calls from a random sample of calls around people that have disabilities and making requests, and just make sure there's not something out there that, we couldn't control before, you get a complaint from a customer or from a DOJ. Anything else before we close? Any other questions, comments? It's been our pleasure, Carlos and I, to be here today. We love talking about this subject. In closing, I would just say, use the tools, making sure you're understanding your risk, support each other, support your customers. And, if you guys need anything or have any questions, Carlos and I are always available. So thank you so much for your time. And if there's no other questions, that will be the end of the seminar.
Thank you, everyone.
Thanks, Karen and Carlos. I did want to add before we give up the continuing education code, that there's a lot of information available, at least on the ADA network sites, to address the person that was asking about how do you figure out what to tackle first. There is, for those who are not as familiar with it, there is a requirement under Title III of the ADA called readily achievable barrier removal.
Yep.
And there are a lot of materials available that can offer some guidance on where do you start? What are the requirements for once you start making changes? What does that mean? Do you have to do everything? Can you just do some? Those kinds of things. How much money are you required to spend on it? So there are some of those materials on our website at adainfo.org if you wanted to look a little more deeply into it, and just also, some tips and best practices too on that process, because it can be a little daunting, and there can be kind of the idea, and I'm sure Karen and Carlos, you run into this, where if I do nothing, it's better than if I do something, because if I do something and I do it wrong, it's going to be worse. And that's is not the case. So be brave, dive in and get started, and know that there are people out there who've done this before, that, you could reach out to, who can guide you through this. You can also contact us. But there, don't be scared to get started.
Yeah. Great advice, Carlene. I think you have page 33. People are waiting for it, I think.
That is correct.
Right. Say that again.
Be brave.
That's right. Be brave.
Be brave, be bold. I want to say that ada.gov/cases has all the cases that we discussed today and even more. And if you also go into ada.gov, there is a checklist for physical accessibility that is kind of like a resumed or a summarized Department of Justice approved checklist to check your physical location. It is 19 pages, or between 19 and 25 pages, but it is significantly smaller than the physical accessibility requirements, which are like 200, 300 pages. So that is also a good start in terms of what you want to go through. It takes you through the major areas in the checklist: path of travel, your bathrooms, and it allows you, it serves as a blueprint for you to document too. Yeah. It allows you to keep track of information there.
Great advice, Carlos.
It is located in ada.gov. Yeah.
Yep.
I can see if I can find the most appropriate link to it. But it is if you navigate through ada.gov, which is the Department of Justice website, they have really good resources there.
Yep. Great advice. Carlene, did you have something else?
No, I think at least in terms of adding stuff in there, I think I'm good. So I am going to move ahead. And again, thank you again, Karen and Carlos. That was really helpful information. And it's always great to get information from the frontline people, the people that are in the field trying to make these changes, and also do things like get buy-in from their employer, which can be challenging. Thank you so much to everybody who joined us today. We are the Mid-Atlantic ADA Center. You can reach an ADA center from anywhere in the country by calling 1-800-949-4232. And also the local number, if you are in our region, is 301-217-0124. Or I'm sorry, outside of our region. And then you can reach us at adainfo@transcend.org. Just a little heads up about next month's webinar. It will be on enhancing accessibility in hospitality with a couple of people from an organization called Visitable. So stay tuned. Join us in April, and you can see the webinar schedule at adainfo.org. Thanks again, everybody who joined us, and have a great rest of your afternoon.
Bye, everybody. Thank you.
Thank you.